Today we'll talk about two topics of law that currently gathers a great deal of public attention based on a number of fact situations that find themselves in the maze of the criminal court systems. That is competency to stand trial. What does that mean? And we'll talk about legal insanity. We'll also discuss various problems with the insanity defense, as well as from a legislature standpoint, the need to not only address mental illness, to be made aware of the reality of mental illness so that bed space can be made available to treat our mentally ill within the criminal justice system. Legal competency consists basically of two tenets. One must understand the nature of the proceedings against him. This is more than just acknowledging who the judge is, who the prosecutor is, what I'm charged with. There has to be an in-depth understanding of the nature of the accusation and of the proceedings that are taking place. It is not simply a memorized rote system, much like a child would do in memorizing the catechism, not understanding the words behind, or not understanding the meaning behind the words, but being able to specifically use the words based on memory. The other tenet that is important is to remember is that the defendant must be able to assist his attorney in his own defense. And frequently this is a very high hurdle to make. As a perfect example, and we'll drift into the insanity by rote here in a minute, but as a perfect example, you may have a defendant that by all objective evidence, medical records, medications, expert opinions, meets the insanity definition. However, the individual refuses to acknowledge the fact that he or she was involved in the actions made the basis of the criminal indictment pending against him. One must be able to acknowledge, yes, I somehow was involved in order, but I was crazy at the time. Crazy being equated to legal insanity.